Hello, friends, good evening. Today we are going to learn about a very interesting topic, which is mode of acceptance. And before we start, I would like to share one thing with you. Most students who are preparing for CLAT think that they know acceptance just because they have memorized a few sections or just because they have read a few sections in the Indian Contract Act. But I can tell you from my experience during my corporate law career and when I was preparing for CLAT and whatever I learned during my journey, right from the preparation till the time I got AIR 36 in CLAT 2013 and AIR 47 in ALET 2013, I realized that the mode of acceptance is where most aspirants lose their marks. And you will understand that today. And even in actual world, I've seen a lot of cases where a lot of corporate lawyers lose their cases because they don't understand this concept of mode of acceptance. And it is this difference between a binding, it is this which makes a difference between a binding contract and a total legal mess. But before we decode mode of acceptance today, let's test your foundation. We have already covered that acceptance must be absolute and unqualified. And if you change even a comma in the offer, what is it? It becomes a counter offer. If you change even a comma in the offer, it becomes a counter offer. And what happens in case of a counter offer? The original offer dies. And we also know by now that an acceptance needs to be communicated. And mental intent has no value in the eyes of law. We spoke about it a number of times that just because you accept something in your mind doesn't make it a legally valid acceptance. You have to communicate it to the offerer. Now here is a quick brain teaser before we start. Let's say if I offer to sell you my car via email, but you reply via WhatsApp. Question: is this a valid acceptance? Pause the video right now and type valid or invalid. Valid or invalid. And I'll reply to each one of you. And this will help me understand whether you're understanding this concept or whether you're able to apply your logic or not. I want to see how many of you actually understand the manner of acceptance before I tell you all the intricacies and all the tricks associated with this area of law. Okay, so let's start our discussion for today, which is mode of acceptance. We discussed in the last two classes that acceptance can be communicated in any of the following three ways. Number one, in writing. Number two, verbally. Or number three, by conduct. Today we will take it one step ahead and we will talk about a very important principle when it comes to acceptance. And the principle is acceptance should be communicated in the manner prescribed or indicated by the offeror. It means that while we know that acceptance can be communicated in any of these three ways, it is the discretion or it is the choice of the offerer as to what sort of acceptance does he require from the offeree. So it is the offerer's discretion or choice as to what will be the mode of acceptance. Pay close attention because it is quite clear that the discretion is that of the offerer and not of the offeree. Offeree does not get a choice here to decide that, okay, I will communicate my acceptance in a particular manner. If the offerer has clearly said that the offeree needs to communicate his or her acceptance in a particular manner, then the offeree has to do that. Let's look at an example. There are two parties, A and B. A is the offerer, B is the offeree. A makes an offer to B and says that if you are fine with my offer, please convey your acceptance by email. So in this case, the offerer has clearly prescribed the mode of acceptance that the offeree needs to accept by way of email. Okay. So when offerer explicitly, this is the first scenario that we are discussing, when the offerer explicitly prescribes the mode of acceptance, then the offeree has to communicate the acceptance in that mode only. That is the mode which the offerer has prescribed. Second scenario could be when the offerer does not prescribe any mode of acceptance. And we will take our famous pen example that I keep talking about. A and B. A tells B, will you buy my pen at rupees 10? This is the offer from A to B. Has A prescribed any mode of acceptance here? Has A said anything to the effect that B needs to communicate his acceptance either in writing or verbally or by his conduct? A has not said anything about the mode of acceptance. So, how should B communicate his acceptance to A? This is what the second scenario talks about. When the offerer does not prescribe any mode of acceptance. The law says that if no mode of acceptance has been prescribed by the offerer, then acceptance may be communicated in any usual or reasonable manner. Simply means that in case there is no mode of acceptance prescribed by the offerer, then the offeree can communicate his or her acceptance in any reasonable or usual manner. So in this scenario, when A makes an offer to B and asks B if he is ready to buy A's pen at rupees 10, what can be a usual and reasonable manner of communicating acceptance? Logically speaking, B can simply reply to A's offer verbally that I am fine with your offer and I will buy it at rupees 10. So in the above example, verbal communication, verbal mode of acceptance can be said as a usual or reasonable manner. So we have looked at two scenarios till now. One, when the mode of acceptance is prescribed, and second, where mode of acceptance is not prescribed. For the first scenario, where the mode of acceptance is prescribed, we saw that acceptance needs to be communicated in that mode only. And in the second scenario, where there is no mode of acceptance prescribed by the offerer, then acceptance could be communicated in any usual or reasonable manner. However, there's a very interesting provision in Indian Contracts Act. And this is different from what we have in the United Kingdom. In the United Kingdom, law is quite clear that when a specific mode of acceptance has been prescribed by the offerer, the offeree does not have any choice but to communicate his acceptance in that mode. If the offeree does not communicate his acceptance in that mode only, then it is not a valid acceptance. But in India, we have a slightly different situation. And this is coming directly from the Indian Contracts Act. Okay. So Indian Contract Act says that if the offerer, and we're talking about situation 1 that we had discussed, where there is a specific mode of acceptance prescribed by the offerer. If the offerer prescribes a particular mode of acceptance and acceptance is communicated in a different mode. Now, here comes the interesting part. The acceptance does not automatically become invalid. Okay, we just saw that in the United Kingdom, the law says that in case the offeree does not communicate his or her acceptance in the prescribed mode, then it is not a valid acceptance. But the Indian position is different. Indian position is that just because an acceptance has not been communicated in the prescribed mode doesn't mean that acceptance becomes invalid automatically. So that leads us to a question: what happens to this acceptance then? Does it become, is it a valid mode of acceptance? Because when the law says it doesn't become invalid automatically, what is the law trying to say here? Let's try to understand that. The law says that in case acceptance has not been communicated in the prescribed mode, then the offerer must object to such acceptance in a within a reasonable time. Okay, we can clearly see that this is quite an interesting proposition. It says that if the offeree doesn't communicate the acceptance in the prescribed mode, then the burden is on the offerer to object. Now, here the law puts the burden on the offerer. Now, let's understand this with the help of our A and B example. If A tells B that if you want to buy my pen, you send me an email confirming giving me your acceptance. But B calls A and says that I'm okay with your offer and I will pay you rupees 10. So B has not communicated the acceptance in the mode prescribed by A. A wanted an email. B has made a phone call. As per the Indian Contract Act, burden is on A. A should object. A should object to B's acceptance in a reasonable time. The Indian law doesn't say that. The Indian law clearly says that B's acceptance, even if made in a different mode, does not become automatically invalid. In fact, it is the offerer who should reject, who should object to that different mode of acceptance. Okay, and what happens in case the offerer doesn't object? Let's say A does not object. If the offerer does not object, the acceptance becomes valid. This is how our legal system is. Our legal system with respect to this area of law is different from the legal system in the UK. Acceptance becomes valid. So in the A and B example, if A doesn't object to B's mode of acceptance and doesn't tell B within a reasonable time that if you want to buy my pen, you communicate your acceptance via email only, and this phone call acceptance will not do. If A doesn't do that, then B's acceptance becomes valid even if B had chosen a different mode. Now we'll understand it better with the help of one more example. Suppose NLSIU Bangalore sends you an offer letter saying you have been selected for the BA LLB course. Please confirm your acceptance within 7 days by registered post. So NLSIU has clearly prescribed the mode of acceptance, that if you are okay with their offer, then you will have to confirm your acceptance by registered post. Now suppose you do not send a registered post. You understand what a registered post is? So just think of you sending something via a post office. Okay, registered post, to be precise, is a kind of post where the postman has to deliver that post only to the person whose name has been mentioned in the post. So if you say that you are sending a registered post to NLSIU, postman cannot give it to anybody else. Postman has to give it to NLSIU only. Okay, so NLSIU wanted your communication, wanted your acceptance in that format, but you do not send a registered post because sending a registered post you thought is a hassle. It's difficult because you will have to go to the post office and then spend your time, money, etc. So you decide to send an email. Instead of a registered post, you send an email confirming your acceptance. After that, NLSIU does not object for a month. And when you confirmed your acceptance, let's say after that you made the fee payment also. After a month, when you go to the college, you find out that NLSIU has rejected your candidature. So your seat no longer exists. When you ask them what happened, I confirmed my acceptance. So why is my name not there on the list? NLSIU tells you that we wanted an acceptance by registered post. You did not send us a registered post. So you forfeited your seat. You had 7 days to send your acceptance by registered post, which you did not do. Therefore, you did not accept our offer. Now ask yourself, in this case, is your acceptance invalid just because you did not follow the prescribed mode? If you are the judge in this matter, how would you decide this case? Your mind should clearly think about the principle that we just discussed, that in the Indian Contract Act, it is clearly written that merely because acceptance is communicated in a different mode does not automatically make that acceptance invalid. So you will apply this provision of Indian Contract Act, which says that under the Indian Contract Act, such acceptance does not automatically become invalid. So this is your first principle. In applying this, your first conclusion would be, just because this student did not send his acceptance by registered post, which was the prescribed mode of acceptance, it doesn't mean that the student's acceptance has become invalid automatically. But there is something more in the Indian Contract Act, which we had discussed. Now let's apply that. Indian Contract Act after this says that burden is on the offeror to reject or to object to the acceptance prescribed in a different mode. Now you apply this principle to the facts at hand. Did NLSIU, which is the offeror, object to the acceptance made by the student? The answer is no. NLSIU never objected. They kept quiet for a month. After the student had sent an email saying that I accept your offer, there was no communication from NLSIU to the student that no, email acceptance will not suffice. You should send it. You should send your acceptance by registered post. There was no such objection. Therefore, it brings us to the last element of this principle, which says that if the offerer does not object within a reasonable time, the acceptance becomes valid. Now answer yourself. You know for sure that NLSIU did not object. For how many days? They did not object for a period of 1 month, which is a reasonable time. Had they not been okay with the mode of acceptance, they should have communicated it to the offeree within a reasonable time. Not objecting for a month is way beyond reasonable time. Therefore, the acceptance given by the student in this case is a valid acceptance. Okay? Therefore, NLSIU is bound by the student's acceptance. Now, this is a very tricky area and a very interesting proposition laid down in law, because logically you could be thinking that this is quite bizarre or quite absurd, because if the offerer is clearly saying that I want this acceptance in a particular mode, and if the offeree does not reply in that mode, shouldn't the acceptance become invalid? But surprisingly, that is not the position in India. In India, the position is that the offerer has to object within a reasonable time if the acceptance has been prescribed in a different mode. And if the offerer does not object within a reasonable time, then the acceptance given in a different mode also becomes valid. Okay, so let's summarize. We saw that acceptance should be in the mode prescribed by the offerer. That is our first principle. Second, we saw if no mode is prescribed, then acceptance can be given in a usual and reasonable manner. And third, departure from the prescribed mode does not automatically invalidate the acceptance, and the offeror must object to such acceptance within a reasonable time. If he does not object, acceptance becomes valid. Okay, this is our summary for today. If you remember these points, mode of acceptance questions will not be difficult for you in CLAT. Especially remember this area, because this is where most of the people get confused, and also because this is the provision that we have in the Indian Contract Act goes against our logic. So therefore a lot of people get it wrong. All right, in the next class we will talk more about acceptance. Till now we have done 3-4 classes on acceptance, but we still have a lot to cover, especially when is acceptance complete. That is going to be our focus in the next class. Until then, study well, study wisely. And if you have any questions so far, please feel free to comment. I will personally reply to each of your comments as soon as possible. Thank you so much.